Welcome to Changing Higher Ed, a podcast dedicated to helping higher education leaders improve their institutions. With your host, Dr. Drumm McNaughton, CEO of The Change Leader, a consultancy that helps higher ed leaders holistically transform their institutions. Learn more at changinghighered.com. And now, here's your host, Drumm McNaughton.
Thank you, David. Today we welcome back a special guest, Mike Goldstein, Managing Director for the Center of Higher Education Transformation at Tyton Partners. Mike is a pioneer in the development of the legal environment in higher education and a counselor at the highest levels of legislation. He founded the law firm Dow Loans in 1978, which merged into Cooley in 2014, and was a senior partner there for 7 years before moving to Tyton. Mike joins us today to discuss the recently filed lawsuit, Florida versus the Department of Education, its background, the reasons behind it, and its implication for higher education institutions and accreditation. Mike, welcome back to the program.
Well, thank you. This is a real pleasure. Always enjoy having a conversation with you.
Likewise, and this one goes right back to your wheelhouse. This isn't a merger. This is a legal case that we're talking about. The state of Florida versus the Department of Education. Before we jump in, would you mind sharing a little bit of your background with our guests?
Sure. And let me make very clear, I have spent the larger part of my professional career practicing law, heading the higher education practice at a couple of large law firms. But I'm not here today to talk at all as a lawyer, because I think what we're dealing with, and this is the lawsuit brought by the state of Florida, by Governor DeSantis' Attorney General, against the U.S. Department of Education to prevent it from implementing provisions of the Higher Education Act regarding institutional accreditation. And while there are some very interesting legal arguments regarding the constitutionality of the particular law in question, this is very, very much a policy argument. This is very much an argument of ultimately who controls what institutions do, how they do it. It's important to recognize that this should not be dueling lawyers as much as it's dueling philosophies with regard to the independence or lack thereof of colleges and universities. I was a university administrator for a number of years. I've been the chair of the board of 2 private universities. I have a lot of experience in the field. I'm now in a firm that does investment banking and strategic planning in the education vertical solely. But again, I want to treat this as a policy issue, not as a legal issue.
Well, thank you. Appreciate that. If you would, give us a little bit of background. How did we get here? What's the background on this case? Because for me, it's fascinating.
It bears a certain resemblance to Governor DeSantis taking on the Walt Disney Company. He was offended by the political position taken by Disney with regard to certain actions taken by the state with regard to treatment with sexual orientation and transgender. And the state passed certain legislation to, in effect, punish the Disney Corporation, which of course now has gone to court, challenging what the governor has done. And there is the famous line, "Don't mess with the mouse." And we'll see how that all comes out. But this is another example. Florida is in the realm of the Southern Association of Schools and Colleges, SACS, that is the accrediting agency for the Southeast United States. And SACS has, and we discussed this on a previous podcast, SACS has a quite activist president who has been very willing to stand up and say when she thinks that there has been undue political interference in the conduct of an institution within a state, to suggest that violates institutional independence and should not be permitted. And if it goes on, that the accrediting agency may take action against the institution. That has some very basic issue involved, because the SACS as is the case with all the accrediting agencies, has a very clear policy that it is the board of trustees of an institution that has the ultimate responsibility to govern the institution. And that board should be acting independently of any other authority, subject obviously to applicable law, subject to the appropriation of funds for a public institution, and so forth. And in a couple of cases, government officials in Florida, Governor DeSantis and his predecessor, took certain actions that Dr. Whalen thought went beyond that line. In one case, Governor DeSantis's predecessor proposed appointing a person to the presidency of an institution, essentially telling the board that that's who they should appoint. And Dr. Whalen objected to that. And in this more recent situation of the state taking very, very direct action to restructure certain of the institutions, including in the case of the New College of Florida, which has been really a bright shining star among innovative institutions, but also quite progressive in terms of the politics of the institution, the kinds of students it attracted, replacing its board, bringing in a president of a much more conservative bent. And the question being raised, is this undue political influence on the conduct of the institution? So those were the triggering factors. The state then passed a law at Governor DeSantis's inception that would require every institution in the state to change its accreditor. Initially, it was to change its accreditor in a relatively short cycle. So 2 years, 3 years, 4 years, and then you have to change your accreditor. And the reaction to that from everybody in higher education in the state was, hey, that's crazy. It costs us a small fortune to go through a process like that. It's enormously disruptive. It makes no sense. The real intention was to get institutions out of the purview of the Southern Association. So they changed it, saying that within 2 years, all of the public institutions in Florida would have to change their primary institutional accreditor. And in addition to the 7, what used to be called regional accreditors, they're now institutional accreditors, there are a couple of others that are relatively new that those of a conservative bent view as more sympathetic to the views of Governor DeSantis and his colleagues. And the suggestion clearly that that legislation is that they should at least get out of Sachs, if not go to one of these others. And of course, the underlying component, I think, is to put such pressure on organizations such as the Southern Association that they would back away from positions trying to protect the independence of institutional boards and allow states to take a more affirmative role in what they do. It's kind of the underlying question here is, why do we have this process in the first place? Why doesn't the Department of Education simply have a process for determining what institutions are qualified the same way that the federal government decides what drugs are suitable for use in medical treatment, the Food and Drug Administration? The reason for that is that education has typically been considered something outside of the purview of the federal government, at least the control of education. And there's a provision in the general legislation that covers all federal education programs, the General Education Provisions Act. And it basically says the federal government is prohibited to exercise any direction, supervision, or control over the curriculum, program of instruction, administration, or personnel of any educational institution, school, or school system.
Mm-hmm.
Okay, so that is primary language. So here's a conundrum. Federal student aid program is created in 1965, starting with Pell Grants and a relatively small loan program. And the federal government had to determine what institutions would be qualified to participate in these programs. Now, they had already asked the accrediting agencies that existed at the time to accredit programs offered by institutions that were enrolling veterans under the GI Bill. So there was some experience with this process. And this now became expanded to cover all institutions taking part in the student aid program. So they were essentially outsourcing to an independent third party to determine the quality and integrity of the academic program so that it would be appropriate to use federal funds to support students going to those institutions. That would seem to make reasonable sense. The law also provided that the Department of Education was to determine whether each such accrediting agency was acting effectively, efficiently, and with integrity so that the watchdogs were being watched. Now, that's the process that has been in place for well over half a century, and generally, with some rough spots here and there, it's worked pretty well. The states approve institutions to grant degrees by whatever criteria they have. In some states, particularly back in the 1960s, had almost no criteria whatsoever. In some states have and still have very prescriptive rules, New York being the arch example of that. And then the school would have to get accredited by an accrediting agency the department has determined to be a reliable arbiter of institutional quality. And that's the words that are used. And then the Department of Education would determine that if the institution has the financial stability and the administrative capability to manage the student aid programs, it could enter into a participation agreement, give Pell Grants, loans, be in the federal family education loan program, the old privately run loans, and then in the direct loan program, which is what we now have, for over the years, literally trillions of dollars of student aid. So that's how we got where we are.
Mm-hmm. That's quite a bit there. And that current situation we have now is it's NASICI that grants the authorization to the accreditors, and the accreditors give their stamp of approval for institutions.
Well, it's not. It's NASICI is the National Advisory Committee on Institutional Quality and Accreditation, some combination of those,
something like that. Yeah.
But NASICI is an advisory body that's made up of individuals, some of whom come from institutions, some of whom come from accrediting organizations, some of whom come from the general public,
mm-hmm.
and numbers of whom are appointed by the Congress and by the administration. They review the accreditors. The work is done by employees of the department who do a report. They review the report. They then make a recommendation to the Secretary of Education, and it is the Secretary, as an official of the federal government, who decides whether an accreditor should or should not be approved for this purpose. So the accreditor has a significant degree of responsibility in overseeing what the accrediting agencies do and how they do it. And on occasion, the secretary has revoked the accreditation, the approval of accrediting agencies, where those accrediting agencies have, in the department's view and in NASICI's view, failed to adequately carry out their oversight function.
Got it. So back to Florida versus the Education Department. There's a lot of different things at play here. There's federal laws, the 10th Amendment, Reserve Powers Clause, the constitutional argument with respect to the state's responsibility versus the federal government. Would you go into that for a little bit?
It's interesting that the Florida lawsuit kind of tiers what it is seeking from the courts. And again, this is just a complaint filed in federal district court. The U.S. Department of Justice has yet to file a response because it was only filed on the 21st of June. But it first asks the court to determine that basically the accreditation requirement, that outsourcing institutional assessment of institutional quality to a non-governmental entity is an unconstitutional delegation of government authority. That's part number one.
Mm-hmm.
That's a pretty broad assertion. There were some cases way back when that said the government can't simply hand over regulation of industry to the industries. This is different, I would argue. I think most people in higher education would argue that. This is using a mechanism to avoid violating the notion that the federal government should not be involved in determining institutional quality.
Okay.
If the court denies doing that, then the complaint goes from the exceedingly broad to the exceptionally narrow. What Governor DeSantis is really pushing back against is the Department of Education appearing to be restricting the ability of institutions to simply change their accreditor, to walk away from the Southern Association and go to someone else. The department has had a rule which they, after Florida passed this law, which they strengthened, that says institutions have to show good cause to change accreditors. And in choosing an accreditor, the institution has to be acting voluntarily.
Ooh, that's big.
And the suggestion being made here is if you are acting by compulsion of law that you must change your accreditor, you're not acting voluntarily, and therefore you don't meet the standard, and therefore you cannot change your accreditor. So we have what can be most easily described as an impending head-on collision.
Would that be called the DeSantis rule?
That is, one could call it that. But that's the narrow part of it. And it's saying, look, if we can't get this whole thing thrown out, just tell the Department of Education they can't get in the way of schools changing their accreditor. Now, that's sort of going, I wasn't going to say from the sublime to the ridiculous and characterize it as you are, but from the extremely, extremely significant constitutional issue to a very narrow issue. But I think there's a lot more behind this. And it's less legal issue than it is social and political.
Okay.
A major component of accreditation is the concept that institutions act independently, subject to the ultimate responsibility of an independent board of trustees. And by independent, the interpretation has been that the people who are sitting on the board are not employees of the institution. They're not directly responsible to the institution that they are supervising, but they are the ultimate authority. And what Governor DeSantis and others are pushing back on, and he is not the only person with this bent at all, is that particularly with public institutions, that they are creatures of the state, and they are ultimately responsible, arguably, to the state legislature and to the state government. And if the legislature or the state government directs that they should act in a particular way, then they should not be prohibited from doing so. That obligating a board of trustees to act in accordance with what their owner, and that's the term that is used in the lawsuit, that the state of Florida is the owner of the public institutions, that if the owner says this is what you do, it's what they need to do. Now, there's an interesting analogy here in the for-profit education sector, where the same rule applies to for-profit institutions, that the board must be independent, and the requirement is that a majority of the members of the board are independent of ownership, that they're not shareholders, that they're not directors of the parent company, that they're not employees of the parent company, to provide some level of insulation between the financial interests of the parent, who are the owners by law, and the conduct of the institution. And that was a piece of the compromise of allowing for-profit institutions to participate in the student aid programs by having that kind of a rule in the accreditation standards.
But doesn't that go directly with this particular case, the state of Florida, or any public institution? Isn't the state the owner?
Well, that's the point. It is analogous. And the argument that is made on the higher education side is that institutions should be insulated from the vicissitudes of the political process. And the argument that is made on the political side, the political process is intended to convey the will of the people as demonstrated by those they elect to the legislature and those they elect to the governorship. And it is perfectly reasonable that that should be translated into how the institutions operate, and certainly into how the institutions are governed. It's a philosophic issue of should the institutions be independent versus should they be simply creatures of the state. Now, K-12 education, nobody argues that the State Board of Education is an independent agency. It is an entity of the state, or that the local board of education, which is typically made up of partisan elected officials, or in some places, New York City, for example, there is no board of education. There is a department of education headed by a commissioner who is appointed by the mayor. So at the K-12 level, we don't think about that level of independence. They are public bodies administered by government agencies. We've created that independence in higher education. Personal view, it's a good thing because there is so much more complexity in higher education. There is so many issues of philosophy, of freedom of thought, the whole notion of faculty being able to teach and say what they think is right, and students being able to think and say what they think is right, is that level of insulation is very valuable. There were those who would argue that, and I think what we're hearing now is that's gone too far.
Mm-hmm.
And that institutions have veered away from the popular will. And I think a lot of this is this notion of, at least for the public institutions, we as the public governing body have a right to more involvement. And if the accrediting agency who is responsible for our institutions doesn't agree, then either we get rid of the accrediting agency, that's the first part of the lawsuit, or if we can't, that the institution's hands are unchained to go to another accreditor.
This makes sense from a logic, legal perspective. But as you said earlier, swapping accreditors is a very, very expensive job. And what's to say that another accreditor doesn't say, well, we need an independent board here as well?
Well, that's the challenge. Part of it, I think, is firing a cannon shot across the bow of the Southern Association and the other accreditors, saying, now you folks had better back away from the kinds of restrictions that you're imposing and the kinds of things that you're trying to influence. Part of it is encouraging other accreditors. And there are, in addition to the 7 formerly regional accreditors, there are now a number of other institutional accreditors, tracks, and several others that are somewhat more narrowly oriented, but that clearly have philosophies that might be more comfortable to a Governor DeSantis and others. And whether institutions would want to go in that direction. Again, if you're a public institution and you're told you have to change accreditors, and it is becoming very clear that you need to go to an accreditor who is not going to create the same problem, that may become a more attractive route. Accreditors, there is right now, one of the things that occurred, and this is also relevant here, during the previous administration, one significant change that was made in the accreditation rules was to eliminate the monopoly, and the term has been used about accreditors, and it was not wrong for a very long time. There were 7 regional accreditors, and the country was divided into 7 regions, and they could only accredit institutions within their region domestically, and an institution in the region could only go to its own regional accreditor. So if you were in Florida, you were stuck with Saks, and Saks was stuck with you.
Mm-hmm.
The rule was changed so that what used to be called regional accreditors, and they're now called institutional for this reason, can accredit institutions anywhere, and institutions anywhere, and literally it's globally now, institutions can go to an accreditor and say, we would like you to accredit us. And that's actually happened to a significant extent, with two of the accrediting regions being particularly hospitable in this regard, and that's the Western Association and the New England Association. And because they have been more open to innovation, particularly initially WASC. So institutions that were not located in basically California and Hawaii have gone to WASC and said, we would like you to accredit us because you're open to new innovative ideas that our accreditors back home are not. And the accreditors have been open to that. Now, there was a fear when that rule was imposed that it would result in a race to the bottom. Accreditors were going to open up their arms and say, we don't care who you are, as long as you're able to pay our outrageous fees, come on and be part of us. And that's not happened.
No.
But because there is that competition, and because now there is this political pressure, there is a question whether one or more of the regions will say, look, we're not going to look at it with quite as close an eye as might be the case otherwise. Interestingly, the Southern Association has said they are not interested in accrediting institutions outside of their region. Interestingly, they accredit schools outside the United States.
Correct.
But not schools physically located in the United States, but outside of the Southern region. So is there a possibility that there will be different rules with regard to the kinds of issues that the institutions are dealing with in Florida? It's certainly possible. How would that be treated by NSEKI, by the Department of Education, in terms of the approval of the accreditors? It's an interesting question. So the accreditor, on the one hand, is looking at the states and saying, all right, they're putting pressure on us and on the institutions. How do we adapt to that? They're also looking at over their shoulder at the Department of Education and NSEKI saying, well, wait, if we loosen these rules, is NSEKI going to come back and say, wait, you're not acting with integrity, you're not properly overseeing the institutions, and we're going to question your continued recognition? So this is setting up a whole other round of potential disputes between accreditors on the one hand and states, and accreditors and the U.S. Department of Education.
This is going to be interesting. At this point, it's just more information out there. You said earlier that the department has not filed a rebuttal to this. Where do we go from here?
Well, the Justice Department will obviously answer. There may be negotiations, and it's certainly not uncommon for lawsuits to be settled. And so there may be a resolution, whether involving a change in policy on the part of SACS, a change of policy the part of the state of Florida, change of policy in the part of the Department of Education. Am I sanguine that will be the case? I don't think so. I think that Florida has certainly taken an exceedingly aggressive position. What I have heard and read from my colleagues in the legal profession is that they've gone way out on a limb in terms of the legal argument. But there are a number of cases that have been resolved where a few years ago, the answer would certainly have not been what we've seen today. And we just had a decision today in the Supreme Court with regard to affirmative action. And not that many years ago, it would have been considered inconceivable for that to be reversed. So you never can predict what judges will do, what courts will do. Is this a case that is likely to go to the Supreme Court? I would guess not, but it's certainly not inconceivable that it would. There's another component here that's interesting, and it's a issue of states' rights versus that of the federal government. And we're seeing that in education in different venues. We're seeing that in this case, where the states are arguing federal regulation is impairing their ability to operate, to govern the way they wish to govern. We're seeing it in another situation, and that is with regard to cross-border delivery of online education. And a decade ago, a compact was entered into among 49 of the states, plus the District of Columbia. The outlier is California. I'm talking about the State Authorization Reciprocity Agreement. And it says that if an institution is accredited and is approved by a state, and that state is a participant in the National Council for the State Authorization Reciprocity Act, NC-SARA, then that state can offer its online courses anywhere in the United States without further approval.
Right.
And there are standards that every state has to meet in order to be a SARA participant. In this case, the pushback is not coming from the conservatives, it's coming from progressives who argue that there's not enough consumer protection in SARA, that the states should have more authority. So we have the progressives on one side with regard to the Florida situation, and we have the progressives on the opposite side with regard to the SARA situation. It presents an interesting challenge, although I will say in the SARA case, it's not quite as clear cut because there are numbers of attorneys general who are fairly conservative who also say, hey, we don't want to be constrained by state education rules with regard to how we treat what institutions are doing in terms of our consumer protection obligations. So it's not exactly analogous, but the states are in something of a tug of war, and more so than we've seen in recent years, between what the federal government can do and what the states can do. And these intermediate organizations like SARA, which again is not a government entity and acting for the government, it's the same argument that's being made with regard to the accreditors and the accreditors, which are not government authorities, as to who has responsibility for what. What is ultimately the power of the states? What is ultimately the power of the federal government? And how much of that can be given out to a third party to maintain a certain degree of insulation between the levels of government?
Well, it's like that old curse. May you live in interesting times.
We're certainly accomplishing that.
We certainly are. Well, Mike, as always, this has just been a fascinating conversation. Certainly appreciate your willingness to come on and talk about this. What do presidents need to be thinking about at this point, besides those in Florida?
Presidents have a lot of problems and a lot of issues to confront. COVID was incredibly disruptive. The CARES Act and the money that was made available allowed institutions to survive 3 really dreadful years. But reality is now setting in. The financial pressures are enormous. There is a demographic cliff that's going to be affecting a lot of institutions. But they have to be thinking about the external pressures. If I were a president of a public institution, I am always looking at what the legislature is doing. Regardless of anything else, they approve my budget.
Mm-hmm.
When I was an administrator at the University of Illinois, budget season was always a very fraught time because stroke of a pen could make significant changes. And one did not want to offend the legislature. One did not want to offend the governor. So I don't think there's a huge difference here. This is bringing to the fore something that people really haven't thought about, because the kind of really direct intervention that's happened in Florida is truly extraordinary.
Mm-hmm.
And I think part of the issue that presidents and I think every bit as much board chairs are thinking about is this an aberration or is this a portent of things to come? I don't think we have an answer to that question.
Yeah, it will be very interesting, no doubt. So, well, Mike, thank you. What's next for you? What's next for Tyton?
Well, what's next for me is surviving the Canadian lovely arboreal air that has settled over Washington with this lovely yellow haze. But, we are in a really interesting world in education generally and higher education in particular. There is a little bit of a survivor syndrome. There is a lot of wondering about what new technologies are going to be doing if online learning has made dramatic changes. Artificial intelligence, augmented intelligence, virtual reality are going to be making even greater changes at even greater rates of speed. I don't think anybody knows at this moment what a university is going to look like 5 years from now, let alone 10 or 15 or 20. And I think that's the greatest challenge. How's it going to be funded? What are the students going to be doing? Who's going to be doing the teaching? Who's going to be accountable?
I think you're right. My friend, it's always a pleasure having you on the show. Thank you.
Great pleasure. Thank you.
Thanks for listening today, and a special thank you to Mike Goldstein of Tyton Partners, and for his sharing his views on the recently filed lawsuit, Florida versus the Department of Education. Thanks, Mike. Always a pleasure to have you on the show. Tune in next week when we welcome back Brian Kelly, our resident cyber expert, who will update us on the recent MOVEit hack and its implications for higher education, third-party risk, and the Connecticut Cyber Initiative, which is a model on how higher ed institutions in Connecticut have banded together to train more cyber professionals. Thanks for listening. Until next time.
Changing Higher Ed is a production of The Change Leader, a consultancy committed to transforming higher ed institutions. Find more information about this topic, along with show notes on this episode at changinghighered.com. If you've enjoyed this podcast, please subscribe to the show, and we would also value your honest rating and review. Email any questions, comments, or recommendations for topics or guests to podcast@changinghighered.com. Changing Higher Ed is produced and hosted by Dr. Drumm McNaughton, post-production by David L. White.